Welcome back to the deep dive. Today, we're taking on a topic that is absolutely central to building generational wealth here in South Africa. We're talking about trusts.
We are indeed, and it's a powerful mechanism for asset protection, for wealth preservation. But we have to be clear from the start. South African trust law is, well, it's completely unforgiving.
Unforgiving, that's a strong word. So, our mission today is to give you a proactive guide. We want to pull out the essential knowledge you need to avoid those really costly, sometimes irreversible mistakes.
Exactly. We want to make sure your trust actually does what you intended it to do, protects your family, protects your legacy.
And the real danger here, as I understand it, is that these flaws, these mistakes, they aren't always obvious right away.
That's the scary part. A trust can seem fine for years, but the moment you try to sell a big asset, or, heaven forbid, SARS takes a close look, the whole thing can just fall apart.
And the cost to fix it is staggering.
It is. We're not talking a few thousand rand. We've seen cases, real cases, where the legal fees just to get a court to validate a flawed deed hit R250,000.
Wow. R250,000 just to fix something that should have been set up correctly in the first place. So, okay, the solution isn't about luck. It's about planning. It's about proper management and investing in the right advice.
That's it.
So let's start at the very beginning, the foundation. Because a mistake here just ripples through the entire life of the trust.
It does. And this is where we see the first major setup disaster. It's something we call the template trap.
Okay, the template trap. Tell me about that. Is this about using those generic deeds you find online or get from a non-specialist?
Precisely. The risk is just immense. These templates, they often don't comply with current South African law. They might have old clauses. Or worse, they're missing the really critical ones you need for your specific situation.
And that's where the costs really balloon. We saw that shocking example, didn't we? A founder used a template based on a UK trust.
The UK trust, yes. And for years, nobody noticed. But when it came time to act, the deed was found to be fundamentally flawed.
And that ended up being an 18-month delay, and that R250,000 legal bill we just mentioned.
Just for court validation. It's the classic case of you get what you pay for.
So the prevention here is non-negotiable.
Absolutely non-negotiable. You must use attorneys who specialize in trust law. You need to budget for it, of course. You might be looking at, say, R15,000 to R75,000, maybe more for really complex deeds. But when you compare that to R250,000 rand to fix a mistake,
It's a bargain, an absolute bargain.
it really is.
Okay, so the structure's sound. The next weak point seems to be defining why the trust even exists. You call this the vague purpose clause. Why isn't it enough to just say it's, to hold assets for the beneficiaries?
Because that gives the trustees no mandate, no guidance. Imagine it's 20 years from now. The trustees face a tough decision. Maybe the beneficiaries disagree. What do they refer back to? That vague phrase is useless.
It just leads to arguments.
It leads to disputes, paralysis. The whole thing grinds to a halt.
So what does a good purpose clause look like?
It's specific. It's articulated. The founder needs to be clear. Is the primary goal education? Is it for business succession? Maybe it's for special needs support. You're essentially writing a policy manual for the future. You define what success looks like and how to make choices when goals conflict.
That makes sense. You're building a roadmap. Which brings us to our second section, the people problem. This is where you choose the trustees and the personal risk just shoots up.
It really does. And this is where we see mistake number 4, choosing unsuitable trustees. It happens all the time. People choose based on emotion, a close friend, a parent, not on actual capability, not on financial know-how or impartiality.
Can you walk us through some of those common problem scenarios? Like appointing an elderly parent, for instance.
Sure, the elderly parent. They might not have the energy or technical knowledge for real oversight, but they share full legal liability if something goes wrong.
And they're on the hook.
Completely. Then there's the busy professional friend. They're smart, they're capable, but they have no time. So management gets delayed, deadlines are missed.
And the most dangerous one.
The conflicted family member. The one who uses their position to play favorites. That leads to instant legal challenges and destroys all trust in the system.
But I have to ask, isn't there a risk in bringing in a total stranger as a professional trustee, especially in a small family trust? It could create friction.
That's the exact tension you have to manage. And the best way is with a mix. You need family trustees who understand the dynamics, the family values, but you balance them with a professional.
Yeah, impartiality.
For impartiality, for expertise, and for continuity. What happens if all the family trustees pass away at the same time? The professional ensures it keeps going. And remember, you must get their written consent before you appoint them. It's a legal requirement.
Right. And all of this circles back to their fiduciary duty. So if the trustees are solid, then we have to define who they're working for. Inadequate beneficiary designation. Why is saying the founder's family just asking for trouble?
Because ambiguity is an invitation to go to court. Is it? Is it just the kids alive now? What about kids born later? Adopted kids?
Yeah.
Stepchildren?
You have to spell it all out.
You have to spell it all out. You even have to plan for the tough stuff. What happens on divorce? Or if a beneficiary develops a substance abuse problem, the deed has to provide the answers.
Okay. We've got structure, we've got governance. Let's move to Section 3, ongoing management, and what you call compliance catastrophes. This is where SARS comes into the picture, isn't it?
This is very much where SARS comes in, and a perfectly good trust can fail right here. Let's start with a big one, transferring assets improperly.
Meaning you've set up the trust, but the assets aren't actually in it.
Precisely. You have the deed, but the property's deed of transfer wasn't executed. The share transfer forms weren't signed. The asset is still legally in the founder's name.
And what does that mean in practice?
It means it's exposed to your personal creditors. And, critically, it means it's part of your estate when you die. It's subject to estate duty.
And that brings us back to that devastating example of the 5 million rand property. The founder intended to transfer it, but they didn't finish the paperwork.
They didn't. So when they passed away, that property was part of their estate. It triggered 1 million rand in estate duty, plus huge delays, just from procedural error.
1 million rand. Can you quickly run through the main taxes you face just during the transfer itself?
Of course. First, donations tax. That's 20% on the value over the R100,000 annual exemption. Second is capital gains tax, CGT. That gets triggered when you dispose of the asset, even by donating it. And third, for property, there's transfer duty. It all has to be done by the book.
Okay, so the assets are in. The next hurdle is just ongoing tax compliance.
And SARS is incredibly strict here. All trusts, and I have to emphasize this, whether they're active or dormant, have to register for tax and file annual returns.
No exceptions.
No exceptions. And the penalties for getting it wrong.
I'm guessing they're severe.
They're punitive. We're talking penalties up to 200% of the tax due, plus very high interest. We saw a case where a trust hadn't filed for 5 years. The actual tax bill was R50,000. By the time penalties and interest were added, they paid R225,000.
Wow. So the advice here is get a professional tax practitioner on day one.
On day one. And you have to be strategic. Income that stays in the trust is taxed at a flat 45%.
Which is very high.
It's the highest marginal rate. So you need to diarize that key deadline, the 28th of February, to pass a resolution to distribute income. You can push it out to beneficiaries who might be on a much lower tax bracket. It's about being efficient.
Got it. Now, what about the quickest way to just tear down that whole asset protection wall? Commingling funds.
Ah, yes. Using the trust bank account for personal groceries. Paying for your holiday from the trust.
It sounds so obvious, but it happens.
It does, and legally it's catastrophic. SARS can look at that and conclude the trust is your alter ego.
Your alter ego, your personal wallet.
Exactly. They decide it's not a separate legal entity at all. It's just you. And if that happens, all the trust's income and gains are attributed directly back to you, personally, taxed at your highest rate.
So that 45% rate comes right back.
It can, yes. The only way to prevent this is absolute documented separation. If you live in a trust property, you must pay market-related rent with a proper lease agreement. Everything at arm's length.
Okay, that's clear. Let's move to our final section, evolution and preservation. Because trusts aren't static, are they?
Not at all. They're living documents. And a huge failure here is poor investment management. Trustees have a duty to grow the assets, not just sit on them.
You had that example of 10 million rand left in a basic savings account.
For 15 years at a 5% return. After inflation, it lost our 3.3 million in actual purchasing power. If that same money had been in a professionally managed balanced portfolio, it could have grown to our 28 million.
The difference is just, it's breathtaking. That's a breach of their duty, isn't it?
It's a massive opportunity cost, and yes, a breach of fiduciary duty. The solution is a written investment policy. Define your risk tolerance, your goals, and you must engage qualified advisors who specialize in trusts.
And finally, the last piece of maintenance, reviewing the deed and planning for succession.
Crucial. You should review your trust deed every 3 to 5 years, or after any major life event, a birth, a death, a change in assets. And you must plan for succession. You can't have all your trustees retire or pass away at once, leaving a vacuum. You need a clear plan for who takes over.
So if we pull all of this together, it seems like success with a trust isn't about some brilliant secret strategy. It's really about diligently, carefully avoiding these very common and very expensive mistakes.
That's the core of it. Success requires knowledge, diligence, and, frankly, the humility to ask for expert help when you need it.
And an investment in that help.
An investment in professional services, absolutely. The law is just too complex, especially around SARs, to navigate alone. Working with a dedicated specialist, a trust consultant, means you have someone to guide you through these pitfalls, to make sure the trust stays compliant and actually does its job.
To secure that
Or
legacy.
secure the legacy, that's what it's all about.
So, if you're listening and you're ready to secure your wealth, protect your assets, and do it right by avoiding these traps, we really recommend working with a specialist. The insights for this deep dive were based on the work of one such expert, trust consultant Lumka Sturman. You can learn more about her and her approach on her website.
That website is www.lumcasturman.com.
Okay, so a final thought to leave you with. We've talked a lot about the cost of mistakes, hundreds of thousands of rands. But if the real goal is securing the next generation's future, what's the non-financial value of a purpose clause that clearly states your values? And how might that clarity be the most important asset you ever pass on?